Thanks for joining me today for Patent Basics. My name is Gint Silins. I'm a patent and trademark attorney for Australia and New Zealand. I work at the firm Spruson and Ferguson, which is located in Australia. I'm in Brisbane, arguably the greatest place on earth, just putting it out there. And as you can see from the map, Spruson and Ferguson has a network of offices and affiliates throughout Southeast Asia, so we're very well placed to service our clients. Okay, let's get on with it. Patents. Patents are known by different names throughout the world. You've got utility patents, utility models, innovation patents. So different countries have different types of patents and the terms of the different patents differ. Utility patents generally have a term of 20 years, although it could be a little longer. Utility models generally have a term less than 20 years, as do innovation patents. So patents provide protection for new and innovative products. Generally, virtually any kind of product can be patented, provided it's new and innovative and useful. And as for processes, you can patent methods of using products as well as methods of manufacturing products. On the right there, I've got a front page shot of a US patent, so that's what it generally looks like in the US. Talking now about design registrations. In the US, they're called design patents. So unlike patents which protect the inventive concept regardless of the appearance, designs actually provide protection for new product shapes and appearances. If you look at the images, you can see fashion industry items, food items, which is a wafer, a cylindrical wafer, children toys, which is a building block, plush toys, yes, everyone loves Australia, and a kangaroo. Building products, agricultural products, there's a fencing post, there's a screwdriver handle, there's a container shape, a dispenser pump with a fancy green label, and there's an artistic work as well, a print. So in different countries, you can get protection for different types of designs. In some countries, you can get protection for functional designs, which means they don't have to be aesthetic or ornamental in any way. For example, a screwdriver handle might be pretty boring, so that could be a functional design, whereas ornamental aesthetic designs could be something there aesthetic that doesn't need to be for a functional purpose. And some countries like Australia offer protection for both functional designs as well as ornamental aesthetic designs. The US, for example, only allows registration of ornamental aesthetic designs. So why would you register a patent or a design? Many reasons, the most important of which is that the innovation is worth a lot of money, so you need to protect it. Otherwise, it's open for copying by others. So you get exclusive rights to the innovation. You can stop others from making, selling, using, exporting, importing it. Now, without an IP right, it's harder to license technology. But if you do have an IP right in place, then that's very good licensing power. Also, an IP right can help you raise capital. Why would someone invest if it's open for copying? You can also attract commercial partners in some instances, qualify for grants. Who doesn't want grant money? It can also scare off competitors and buy time to conquer the marketplace. Marketing spin. You can have patented or patent pending on your process, which is pretty good marketing spiel. And in some instances, trade secrets are simply not appropriate. So secret herbs and spices, they're only protected if they remain secret. But if someone discovers them, then they're open to copying. So moving now to IP barriers to marketplace entry. Of course, in red, you've got to be aware of third-party IP rights. Look before you leap. Just because you can use your product or process in your country, such as Australia, doesn't mean that you can use it elsewhere. This is because there might be a third-party IP right in that country. So let's say you're using it in Australia, all's good. You can use it in New Zealand because there's not an IP right there owned by a third party, but India and China, there is a pre-existing third-party IP right. Well, then that can be a barrier to marketplace entry or continue use in that marketplace. Here's a scenario. Your product or process can't be sold or used in that country because it's too similar to a registered third-party patent or design in that country. Now, remember that patents protect inventive concepts. So if it was a product, many different products could be protected under that patent. Same with processes. You could have variations in process steps, yet it still falls within the scope of that patent. A design registration, on the other hand, protects the product appearance. Now, your product appearance may be very similar, which may still fall within the scope of that design registration. If you happen to be sued, you may be forced to recall products from the shelves or cease offering services or defend yourself in court. Of course, that's very costly in terms of time and money, and it could even bankrupt you. So you really do not want to go in blind. You want to look before you leap. So what checks do? You check to see that your product or process is available for your commercial use in that country well in advance of launch. So the take-home message is minimize risk, search for IP rights before going abroad. So how do we do that? Patent searching. So the Google Patents database has quite extensive coverage of patents around the world. You can use keywords to do some searching, but again, I recommend that a patent attorney do those searches for you and interpret your search results, because at the end of the day, it's only the patent attorney can advise whether there's likely to be infringement or not in that particular country. Patent Lens has a worldwide database that covers many jurisdictions, and again, you can use keywords to search for technology of interest. eSpaceNet is another worldwide database. Again, it's got quite good coverage, and you can use keywords to do searches. Patent Scope, it covers PCT applications, which are also called International Patent Applications. PCT stands for Patent Cooperation Treaty. I'll be talking about that in a few minutes' time. Patent Scope database also has coverage of a handful of other countries, so it's a good database to search as well. Design searching. The World Intellectual Property Organization, WIPO, has a global design database. You can put in descriptors to pull up designs and search through those images, see if there's anything too similar to yours. It's got good country coverage, but it doesn't cover every country. Not all countries are covered by the databases that I just mentioned, in which case WIPO has a listing of national offices, and following those links, you may get to databases for patents, designs, if they exist, and do some further searching there. Now, this isn't a complete listing. I've just highlighted and read some of the notable jurisdictions that people tend to want to search. And it's time to talk about IP protection. Don't go unprotected. It's a fact, good ideas are usually copied. The possibility is that your product or process might be copied in that country and there is nothing you can do about it. It's too late. So if there's no IP right in place, then it's open to copying. So for protection of IP, patent protect your innovative product or process in each country of interest. Protect your innovative product appearance by way of a design registration. You can do both. Not all countries offer both options. Some countries offer more options, but I won't go into that. Generally speaking, lock up your innovation with an IP right. So this is a very important point. You should protect your product or process whilst it's still secret. That is, it hasn't been put in the public domain, not on your website, no offers for sale. Otherwise, patent or design registration rights may not be available. What happens quite often is that businesses will be seeking expressions of interest at trade fairs overseas, but that constitutes a public disclosure, which means that it may be too late to obtain valid patent and or design rights over your innovation. Now, in some cases, even if it's generally too late, you haven't sought protection before it's been disclosed, some countries have a grace period against self-disclosure. What this means is if you have disclosed it publicly, you may still be able to obtain protection for your invention in a handful of countries, provided you file for protection in those countries by a given deadline. Australia, for example, has a 12-month grace period, so if you publicly disclose it, you can still obtain a valid Australian patent provided you file for protection in Australia within 12 months of the date of first public disclosure. US and Canada have similar requirements, as does New Zealand. Most other countries, basically if it's in the public domain, it may be too late. Having said that, there may be utility models in some countries where there are additional grace periods, so it may not be too late. But again, generally speaking, file for protection before you publicly disclose your product or process, otherwise it's going to be too late. So moving now to patent filing strategy. So generally you file a first application somewhere in the world. If that country is a Paris Convention member country, then that allows you to delay filing in other countries up to 12 months later in Paris Convention countries. So a PCT application that I mentioned earlier is an application that you can file that immediately covers 153 different countries as shown in blue shading. Now it doesn't actually put applications on foot in any of those countries. It just keeps the door open for those 103 different countries. That is, it gives you the option for filing those countries at a later stage. You'll see in red there, it says 30 months. So that's 30 months from your first application filing date. For some countries, it's 31 months. It could be longer, but generally 30 months is your deadline. So at that 30-month deadline, you have to then enter the national phase, which means file in one or more countries of interest. So you might choose Australia, you might choose the US, might choose China. Then the opportunity ends, the door closes for all other countries. So at that time period, at that point in time, you have to decide in which countries to take out patent protection, and the opportunity is lost for all other countries. Now for non-PCT countries, they're represented in green. So the PCT route is not available. So what happens is 12 months from your first application filing date, you have to decide in which convention countries, non-PCT countries, to file for protection. It could be Argentina, Taiwan, Bangladesh, etc., etc. Focusing a bit more on PCT, as I mentioned, there are 153 different contracting countries at this point in time. They're shown in blue. So you can see this is probably the most, you can probably understand this is the most popular route for most businesses who want to obtain protection in a handful or more countries around the world, to keep their options open for multiple countries for as long as possible, for as little cost as possible. Now here I've listed European Patent Organization, various organizations, and what this tells you is that you can file a single application under the European Patent Organization. It's called a European Patent Application, and that single application will cover all member states of the European Union, plus a few additional countries. So it allows you to file the one application, have the single examination, have the grant of the European patent, and then you decide in which countries you wish to validate the patent. So you may wish to validate it in France, Germany, United Kingdom, and then the opportunity is lost for all other member states of the European Union. Now, the Eurasian Patent Organization covers the Russian Federation as well as a handful of other European countries. The two African organizations that I've mentioned there cover different African countries. So again, it allows you to designate, to nominate various African countries in a more cost-effective way and to obtain protection in those countries. Of course, I had to have a disclaimer slide, so I'll let you read that for a second. So thanks again for joining me today for Patent Basics. Feel free to contact me by email. Again, I'm in Brisbane, Australia, arguably the best place on earth, just saying. And I look forward to your questions now. Thanks again.